What's up, everybody? I'm back with part 4 of Ken Kratz answering your questions. These questions are asked by ex-user Vegas Ranger, then answered by Ken Kratz, and then relayed by me on here. Everybody's information is linked in the description below, as well as a link to where you can purchase Ken Kratz's book. Now, let's go over the next set of questions and answered. Again, these are asked by Vegas Ranger and then answered by Ken Kratz. All right, here is the first question for today. Now that you know the list of various sick searches found on the Dassey computer, are you in a position to say if that was available to you, it would have been at the very least a red flag? Ken Kratz's answer. First, let's point out the obvious. We were trying the state of Wisconsin versus Stephen Avery. We had no reason to believe that a shared computer from the Dassey household would hold any relevant evidence to Stephen Avery's case, if relevant at all. We believed the computer searches, files maintained on the hard drive, or possibly chat logs would come up at Brendan Dassey's trial. It appears that most of the relevant clues on that computer were erased by somebody in the Dassey household, as I doubt anybody in that household believed Brendan was going to be charged with Uncle Stevie. I am comfortable in saying that the files were scrubbed to hide potentially relevant evidence against Stephen. After all, he was the only person charged at that time. The evidence highlighted by attorney Kathleen Zellner, specifically the internet porn searches conducted from that computer, would have been inadmissible in any trial against Stephen. Judges are reluctant to allow other acts evidence against defendants due to the possible unfair prejudice that may result. There's no way this evidence would have been admissible under a Denny offer of proof against any alternate suspect. As I understand, Kathleen Zellner has not even established who did what searches. Offered for identity or intent or motive under section 904.04, that is to try and identify another possible killer, the judge would have only allowed searches before the homicide occurred on October 31st. This is my personal opinion, although I am not currently a lawyer and never mean to give a legal conclusion or advice in this series or anywhere else. Question number 2. Name 2 critical things that Brendan said first time without being asked multiple times that had evidence to back it up. Brendan identified who shot Teresa in the head the first time he was asked that direct question. Dassey's defense attorney and armchair legal advocates insist the question investigator Mark Weirgert posed to Brendan Dassey, who shot her in the head, was somehow leading or otherwise improperly suggestive. Nonsense. I mean, he did, man, my recollection, and maybe it's just my recollection, but didn't Mark Weirgert say something along the lines of, now I'm paraphrasing here, obviously, like, we know what happened, we're just going to say it, who shot her in the head? After Brendan was saying other things that didn't lead to him saying that Stephen Avery shot her in the head. That's my recollection of it, that Mark Weirgert say, we know she was shot in the head, or something along those lines, who shot her in the head. Example, police officer interrogates one of the several suspects in a carjacking investigation. He asks, which one of you drove the vehicle? Suspect answers, Billy did it. Is this question leading? Does the question itself suggest the answer? No. It's a direct question and he got a direct answer. Billy. So why is the question to Brendan any different than the above example? Weirgert asked the direct question, who shot her in the head? He got a direct answer. Stephen did. That's not how maybe I'm remembering it wrong. I remember the investigator saying something along the lines of, again, we know what happened, we're just going to say it, who shot her in the head? And then Brendan said he did. No confusion, no guessing, no feeding answers, and physical evidence the bullet was found as a result. The second area I recall Brendan answering the first time was if he knew whether Stephen had scattered the bones from the fire pit anywhere. Dassey not only described how Avery put bones in a 5-gallon pail and drove the golf cart to scatter them, he showed the investigators where on a map he was referring to evidence of scattered, unidentified bones were found on surrounding properties. The next question. Was the RAV4 in the picture with Teresa an actual photograph, or was there any manipulation used? My film editing skills are modest at best. I can crop photos to fit, brighten or darken the image, and place it on my presentation screen. If there was manipulation of that image or any other photo provided to me, I had no knowledge. When I look at the photo you reference, I don't even understand why it's an issue. So, at least here, he's saying that he had no knowledge of this particular photo being manipulated. He's not saying it didn't happen. He's saying that he has no knowledge if it did happen, which is interesting. Did you ever find her original car key and all of her other keys? No set of house or car keys identified as belonging to Teresa Halbach were ever located, to my knowledge. And the last question we're going to go over today. Do you genuinely believe Andy shook, twisted, and pulled the bookcase away from the wall when the evidentiary pictures clearly show the case sitting at the exact same markings on the carpet with all the items still on top? Starting a question with, do you honestly believe, pretty much tells me what you think of Andy Colburn's trial testimony. I mean, that shouldn't really be a shock. Most of the people out there are not in agreement with the way Andy Colburn did anything, really. Yes, I believe the key fell to the floor after Colburn moved the bookcase. Why? Because the alternative requires a finding of cops planting evidence, and that I was therefore likely involved in a cover-up. I honestly believe if any law enforcement or civilian bad actor attempted to plant evidence, tamper with evidence, or hide any aspect of this investigation from me and or my experienced team, we would have known about it. Very large, high-profile, complex jury trials take a great deal of time to prepare. I accepted the appointment as special prosecutor despite the case happening in an adjoining county in Wisconsin. I did it because I felt someone local had to. Teresa was a missing person from our county, so our office was the natural choice. The 3 prosecutors assigned together with Agent Fassbender and Investigator Weirgert spent almost every day of 15 months getting ready for trial. Almost immediately, we viewed the case from the defense side, identifying weakness in our evidence or chain of custody, or any of 1,000 issues were closely scrutinized by every resource we could find. We would not have missed anything that seemed suspicious or out of place. That was our chosen profession, our life's work, seeking justice we all strive for. To be fair to everybody, I guess, what Ken is talking about, I'm not saying it happened in this case, I'm not saying it didn't happen in this case, but it happens. I don't know how often, but it happens. It happens. Evidence is manipulated. Evidence is planted. Evidence is put in a way to either help the prosecution or the defense. It is not a thing that is like out of this world that could never possibly happen. It could have definitely happened. It could have definitely happened with only a couple of people knowing about it. I don't feel like a ton of people needed to know. If 2 or 3 people were involved in it and just pushed everything forward, then maybe Ken Kratz didn't know, or maybe Ken Kratz doesn't know. I'm not saying it even happened, but it is definitely possible, and it does happen. Therefore, since I put every bit of my trial experience and reputation into this case, as did all of the other professionals involved, when it comes down to Ken was crooked or incompetent, and so were all the rest, I need to push back and set everyone straight once and for all. I would never proceed with a case, especially never go to trial on any case that I believed the defendant was not guilty. Stephen Avery was the largest case any of us had ever tried. The prosecution, the defense, the cops, and the court. It was the biggest case the media ever covered. This certainly was not a case to cut corners or put our thumb on the scales of justice. As a prosecutor, I learned that we don't do things because we can. We do them because we should. Watching some of today's district attorneys use the justice system to settle scores or otherwise prosecute for political gain saddens me. I've seen how absolute power can be used to crush those unlucky enough to be targeted by our government. Nothing erodes confidence in our justice system like rogue prosecutors acting in furtherance of an agenda other than a search for the truth. I assure you, Stephen Avery was never treated unfairly, at least not by us. There's a lot in that last question. For everybody out there that doesn't believe Brendan Dassey had anything to do with this crime, because there's, in my opinion, and a lot of other people's opinions, there's no evidence other than a statement from Brendan Dassey that was, in my opinion, again, coerced. I don't agree. I don't think, there's no way in my mind that it wasn't. I've watched it. I don't agree with what Ken had to say in the response to that question there. But the sentence that on any case that I believe I wouldn't take any case to trial that I believed the defendant was not guilty. I don't know. This is not a shot at Ken Kratz. I think that they wanted Stephen Avery so bad that possibly Brendan was just a pawn in this game. They could get Brendan to say and do whatever they wanted, and they knew that after speaking to him. So they did what they did in order to get Stephen Avery convicted. That's just my opinion. Maybe it's way out there. I don't know. But that's what it seems like to me. That's what it seems like happened to me. That they wanted Stephen Avery so bad they were willing to ruin a child's life for the rest of his life. That's a solid chunk of someone's life for something I feel they didn't have anything to do with. Yes, if Brendan took the deal, and originally he would have been out, I think it was in 2021, but why would you take a deal if you're innocent and believe the justice system plays out fairly, and you didn't do it, so you're going to be found innocent? So instead of spending, 2006 to 2021, 15 years in jail for something you didn't do, you can spend 0 instead of being involved in a very flawed justice system and then spending from 2006 to 2048 in prison. I don't know. I get taking the deal because you could be found guilty and spend way more time. I can't say that I would have admitted to doing it. I would have likely did exactly what Brendan did. I'm innocent. The facts of the case are going to prove that I'm innocent, so I'm not going to spend any more time in jail than I need to. I don't know. The entire situation is just extraordinarily sad. But those are the questions today from Ken Kratz. What do you think? Let me know. Leave some comments below. I hope you're having a good day, and I will see you again soon.